Yeah friends, in continuation to the earlier class, we discussed the remaining fundamental rights. Those are right against exploitation. This is still from Article 23 to Article 24. Article 23 says that the prohibition of traffic in human beings and forced labor. So, traffic of human beings and forced labor is prohibited as per Article 23. And as per Article 24, prohibition of employment of children and hazardous jobs such as activities like construction works, mines, where explosives have been used, and in case of railways, this employment of children under the age of 14 is prohibited. So Article 23 clearly says that traffic in human beings and forced labor, beggar, and all these things are prohibited by Article 23, and Article 24 deals with the children under age of 24. Article 21A is also dealt with the children under the age of 14. So what is that under the age of 14? That is right to education, right? So and come to right to freedom of religion. Next right is right to freedom of religion. This is dealt from Article 25 to Article 28. So under this Article 25 to Article 28, like Article 25 says that it is given to all the people, not to just citizens. It is for all the citizens. They can practice freedom of conscience, means they can go for whatever the religion they want to practice. The state will not impose any restrictions on practicing any kind of religion. State will not interfere in any kind of religion. That state doesn't interfere in religion is called secularism. Like state doesn't have any own religion, then it doesn't interfere with any other religions. Everybody is having the freedom of conscience to practice own religion. That is called secularism. Secularism doesn't mean that everyone is given equal opportunity, you can practice whatever they want. It's not equal opportunity for each community, each religion. It is for state doesn't have any religion. That is the meaning of secularism. Then Article 26 that says that freedom to manage religious affairs and establish and maintain institutions for religious and charitable purposes. You can establish institutions based on the caste or community for charitable purposes. You can establish a temple. You can establish a society like Hare Rama, Hare Krishna society. You can establish some other caste society for minority people. These kind of things were provided under this Article 26. And Article 27 that whatever the institutions you have provided, you should not be taxed those institutions. These are these are given freedom from paying taxes. So that is whatever the charitable purposes, the institutions you have opened for charitable purposes, those are not business institutions, those are only for charitable institutions, and these are not given any tax, these are not provided, these are free from tax, these are exempted from tax. And Article 28 says that you have freedom to attend religious instructions or worship in certain educational institutions. You have freedom to attend, you can attend religious instructions in any kind of institutions you want, any certain educational institutions. But any educational institution which is owned by the state, only owned by the state, in this kind of things you cannot go for any religious instructions. You cannot go for any religious instructions in the case of institutions only owned by the state, means government colleges, government universities, and government schools. You cannot go for religious instructions. That is what said by the Article 28. So nowadays the people are saying that you need to practice yoga in school. Yoga, it is okay, it is accepted. And some schools like in the states of Haryana, there is a conflict going on. They are including shlokas in government schools. They are saying that the people should, the children should recite shlokas in schools. But a school is only maintained by the state, so there is a controversy going on. Only maintained by the state, but then if they are imposing slokas from Bhagavad Gita, means they are directly implying Hinduism. So these kind of issues are going on continuously. These have been there in the state continuously. Yeah, this is about the right to freedom of religion. And cultural and educational rights. Cultural and educational rights, this is dealt from Article 29 to Article 30. So what is this Article 29 says is you can practice whatever the culture you want. Earlier in the Article 25 we said that you can practice whatever the religion you want, and you can have a period of freedom of conscience. But whereas here you can practice whatever the culture you want. That is given by Article 29. Article 30 says that the right of minorities to establish educational institutions. So minorities can go for educational institutions only for them. That is what you can see, that Christian minority college, you can see the Jain minority college, you can see the Sikh minority college. These were provided under Article 30. Minorities to establish educational institutions. Right of minorities to establish educational institutions. I want to include one sentence here. In whole constitution, you repeat all the whole constitution, this minorities word was not defined. You cannot find anywhere word minorities except here, that minorities to establish educational institutions. This is what given under Article 30, but the word called minor arrest you will never find in the constitution, and this was not defined also. Yeah, and under this Article 30 only there is some subclass that is saying that no citizen shall be denied admission into any education institution maintained by the state receiving aid out of the state funds. So based on religion, no person should be denied admission into educational institutions. So if you are a Christian, like let us say that someone is a Christian, but he is denied in the Jain institutions. So if Jain institution is only funded by the it's receiving funds out of the state, then they cannot, Jains cannot restrict Christian joining in the Jain. So this is what given by the claim. You cannot deny admission on the basis of religion. No citizen shall be denied on the basis of religion. That is what. Yeah. This is very, very important, and for last fundamental right, that is nothing but right to constitutional remedies. Friend, this is very important. You can note down, this is Article 32. Article 32 is like you can, whenever you feel that your fundamental right is taken away by the government, like if government is acting arbitrarily on you, then you can move to the courts. Then your fundamental right is guaranteed by the court. This is the right to constitutional remedies, and even Dr. Ambedkar considered this as heart and soul of the constitution. This is very important. Heart and soul of which right is called as heart and soul of the constitution. That is called Article 32. So this provides fundamental right. This guarantees fundamental rights to you. The best example in recent times. So what happened is 66A of IT Act. You might have seen 66A of IT Act. This was Supreme Court has suspended this act. So what this is saying that this is against the freedom of speech, means whatever, if you post some comment in Facebook or Twitter, and if it is against any person, then what they are doing is they are coming and directly they filing a case against you, and based on this post some people were arrested. So and they are saying that Article 66A, that if it is humiliating in nature, and then so you are punished, you are eligible to punishment. So, but this is against the fundamental right, that is against the freedom of speech. So, someone moved against to the court, so that this 66A was suspended by the Supreme Court. So, this is what constitutional remedies was given by Article 32. We can move to the court. This is the heart and soul of the Constitution. It is because that right given to citizen who the right to approach this is given. This, you can approach a Supreme Court or High Court, and they restore your fundamental rights. The Supreme Court and High Court can issue orders and give directives to the government and for the enforcement of rights. The courts can issue various special orders known as writs. So what are the writs? The first one is habeas corpus. So habeas corpus says that a writ of habeas corpus means that the court orders arrested person should be represented before it. So it says that please bring him in front of me. That is what habeas corpus. Habeas corpus says authority, whoever who have arrested a person. So please bring please present that person in front of me. That is what habeas corpus. And mandamus means this is writ issued when the court finds that a particular office holder is not doing a job, legal duty. So if someone is escaping from legal duty, then mandamus is the writ issued to the particular office holder. Then what about the prohibition? This is in case of courts. So High Court or Supreme Court, it says that it's given to the lower court, and this is considered a case going beyond its jurisdiction. Let us say there is a court in district A and there is a court in district B. If the court in district A is interfering with the jurisdiction of court in district B, then High Court issues a order to this, a writ to this court A, that is called a prohibition. So if this is breaching, it is going beyond its jurisdiction, then a writ is issued, that is called prohibition. Prohibition is in case of states, friends, in case of courts. Yeah. Then what about Q warranto? Q warranto says that in simple means by what authority you are staying in the, you are having the office. By what authority? It's clearly saying that by what authority. By what authority you are holding the office. There will be some persons who are not fit for the job, but they will be still holding the office. Then if someone moves to the court, then the court will give a direct writ, that is called Q warranto. Yeah. Then what is about certiorari? Certiorari is it is again on courts only. That's lower courts, and higher court says to the lower court that please transfer the pending case to a higher court. That is what about the certiorari. So prohibition and certiorari deals with the courts. And application of fundamental rights to armed forces. See friends, there are some restrictions for armed forces to make them very disciplined, the some of the fundamental rights will be they will be taken away from them. It's intentionally, and they were already given they take the consent from these parties. So this what are this application to how the application of fundamental rights. So this deals with this dealt by Article 34 and 33 and 34 and 35. Article 33 says that power of Parliament to modify the rights conferred by the part of this application to armed forces. Parliament can alter the Parliament can modify the rights given to armed forces. It simply Article 33 says that Parliament can modify the fundamental rights given to armed forces. And what does the Article 34 says? It says that there are restrictions on fundamental rights when martial law is in force. Then like military rule is in force in the country, there will be some restrictions on fundamental rights, and whatever the military rule, military authorities will be given with the abnormal powers to take all necessary steps to control the situation. So Article 35, it says that the power to make laws to effect a certain specified fundamental rights shall vest only in Parliament, not in the state legislature. So whatever the amendments you want to make to the fundamental rights, that can only done by Parliament, not by state legislature. This is what given by the Article 35. That is very important. So with this we have completed part 3, that is about the fundamental rights, and now we'll see what are the previous year asked questions in this topic. The right to property was dropped from the list of fundamental rights by the 44th Constitutional Amendment. This is 44 you need to remember, 44th Constitutional Amendment. The right to equality refers under the right to equality, first option is given, prevents the state from making special provisions for women, citizen and backward classes. No. In fact, in the right to equality, that Parliament is provided to make some special provisions to the women, children and as well as backward classes. So there only we have seen that reservations came into picture. And which of the following which of the following writ, not this wrist, it is writ. Which of the following writ literally means by what authority? Just now we have seen that by what authority you are holding the office. That is what Q112. And the fundamental rights of a citizen can be suspended by the Parliament during any type of emergency. This is also we have seen. The following article of the Indian Constitution abolishes the practice of untouchability. That is Article 17. We have said that. And which of these not included as a fundamental right in the Indian Constitution? So there is a freedom of speech, there is right to equality before law, there is right to constitutional remedies, right to equal wages and for equal work. This is not there. This is included in DPSP, Directive Principles of State Policy. We'll see that. So the answer is fourth one. And point out which of the following is not a right enumerated in the Constitution of India but has been articulated by the Supreme Court to be the fundamental right. So right to equality before the law is there, right to abolition of untouchability is there, right to form associations is also there, but right to privacy is not there. So this is being given under the Article 21, and this says that right to life. Under this right to life, Parliament has Supreme Court, in fact Supreme Court, not Parliament, Supreme Court has articulated that so right to privacy forms under the part of right to life, but it is not a fundamental law. Point out which of the following is not a right enumerated in the Constitution of India but has been articulated by the Supreme Court to be a fundamental law. So this again, right to life is given by the Supreme Court, is given by the Constitution. Equality of opportunity in matters of public employment is given by Constitution under Article 19, and protection of personal liberty, this is also given by Article, personal liberty is given, but right to permanent housing is not given. So protection of you have the freedom. So right to permanent housing is not there, but this is interpreted by the Supreme Court. So this is the answer. So that's it, friends. That's it for the day. Thank you very much. Have a nice day, and don't forget to subscribe the classes. Please follow this fundamental rights so that it will give many marks in the exam. To get good marks, you need to follow this topic. Thank you very much. Have a nice day.